People say that the amendment against slavery was unneeded, as one could argue that the right to not be a slave can be found in the Ninth Amendment. I personally think that as stupid as that seems to imply, you can just make up rights and say the Ninth Amendment covers it.
The amendment to the U.S. Constitution states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. While the Ninth Amendment has been interpreted to suggest the existence of unenumerated rights, it does not specify what those rights might be. While it could be argued that the right not to be a slave is a fundamental right retained by the people, it is important to note that the original Constitution contained provisions that protected slavery, such as the Fugitive Slave Clause and the Three-Fifths Compromise. The 13th Amendment to the Constitution was specifically added to abolish slavery and involuntary servitude, and then it was necessary to overturn these earlier provisions. Furthermore, the Ninth Amendment is a rather general statement of principle and does not provide any specific guidance as to how to interpret the Constitution. As such, it is not a substitute for specific constitutional provisions that provide more precise guidance on killer issues, such as the 13th Amendment's prohibition of slavery.
Yes, and Lincoln nor did the writers of the 13th Amendment use the Ninth Amendment as an argument why slavery was wrong, because they understood at the time the limitations of the Ninth Amendment.
That's correct. The Ninth Amendment of the U.S. Constitution states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. However, and it has been interpreted differently over time, and its scope is not always clear. The 13th Amendment, which abolished slavery and involuntary servitude, was passed a clear and direct statement against the practice, rather than relying on a broad interpretation of the Ninth Amendment.
It has been generally understood that for something to count as an unenumerated right under the Ninth, it would have to be a right that the founders considered important, but that didn't put it in. Lincoln and others, no one knew it would be a losing argument because the founders never argued for a right to not be a slave.
Yes, that is correct. Well, the 9th Amendment to the United States Constitution states that the enumeration of certain rights in the Constitution shall not be construed to deny or disparage other rights retained by the people. However, in the meaning and scope of unanalogy of unenumerated rights under the 9th Amendment have been the subject of much debate and interpretation throughout history. While some argue that the right not to be a slave could be considered an enumerated right under the 9th Amendment, it is important to note that the founders did not explicitly address slavery as a natural or unalienable right in the Constitution or the Declaration of Independence. Therefore, Lincoln understood that, and others understood that arguing against slavery based solely on the 9th Amendment was a difficult and unlikely winning argument.
For example, parental rights, while not explicitly in the Constitution, can be considered an unenumerated right under the 9th Amendment because the founders all expressed their beliefs that parents had certain rights to their children.
Yes, that's correct. The amendment has been interpreted by some to protect unenumerated rights, which are rights that are not specifically listed in the Constitution. This interpretation suggests that the Constitution is not an exhaustive list of rights, and that individuals have other fundamental rights that are not explicitly mentioned in the document. But these really seem like enumerated right based on the enumerated rights are based on the natural law principles that the founders believed in, including the right to privacy, freedom of thought and conscience, and parental rights. However, the scope and definition of unenumerated rights is still a matter of debate and interpretation.
The founders, though, didn't believe in a right to privacy purse. Washington kicked homosexual men out of his military. I believe Jefferson spoke against sodomy and the like.
It is true that the founding fathers did not explicitly mention a right to privacy in the Constitution. However, many legal scholars and judges have argued that the Constitution's text structure and history imply a right to privacy that protects personal autonomy in various contexts. The Supreme Court has recognized that a right to privacy in several landmark cases, including Griswold v. Connecticut in 1965, which struck down a state law prohibiting the use of contraceptives by married couples, and Roe v. Wade in 1973, which established a woman's right to choose to have an abortion. While the founding fathers may not have explicitly envisioned these specific issues, like the concept of good purchase that technical autonomy and the right to be free from government intrusion into certain private matters can be seen as an extension of their broader beliefs about individual liberty and limited government,